in Wisconsin. We've talked about this story. A young woman who has been pushing back against her school in New Richmond, which is, I think, St. Croix County, because boys are in the girls' bathroom, because boys are in the girls' locker room. She's being forced to sue the school because the school won't follow the law. Dan Lennington, Wisconsin Institute for Law and Liberty, I believe it is Wisconsin Institute for Law and Liberty, who is representing her, joins me on the program. We've been over this, Dan. It's the law. You don't allow boys in these spaces. Title IX is clear. The guidance on Title IX was rescinded by this administration. Why does Ella have to, Freeze, I think is her last name, have to sue her school to have privacy in her bathroom?
Well, I think it's that the mind virus that's infected school board members and administrators and guidance counselors and school nurses is so strong that they would rather violate the law than give equal treatment to boys and girls, which is exactly what Title IX requires. Title IX, the language, it's a federal law that was passed decades ago, and it says that no person in the United States on the basis of sex shall be excluded from participation in or denied benefits or be subjected to discrimination based on sex in an educational institution like a high school. And that's exactly what's going on here. There are boys' bathrooms and there are girls' bathrooms. And there is one boy in the school in New Richmond that wants to use the girls' bathrooms. And the girls are upset with this. And what the school has said to Ella and other students is that if they feel anxiety or they're worried about privacy or safety in the bathrooms, then they're allowed to use single-stall bathrooms. And the school has actually, this is a large high school, the school has actually put maps up on the walls. And we have, on our complaint, this lawsuit that we filed, we included a copy of this map. And the schools, and this is all over the school, says, if you are looking to use a single-stall bathroom, please note the locations of the restrooms on the map. And Ella, among other things, and other students, she has literally missed class time because the single-stall bathrooms are located on the opposite side of the school from her classrooms, requiring her to walk a long distance. And she's missed part of her lunch hour. She has suffered anxiety and discomfort based on the possibility that there's a boy in the bathroom every time she wants to go to the bathroom, if she's told her story publicly. And guess who doesn't have to deal with this in New Richmond School? It's boys. So this is the very definition of sex discrimination. Girls have to put up with this inconvenience, to say the least, or discrimination, but boys don't have to. And that's exactly what Title IX was passed to stop. And in addition, our Constitution prohibits sex discrimination. And so this is unconstitutional, and it violates federal law, which is something that protects the rights of students like Ella and all the other girls that are in that building today.
So they lost, the people who put this policy in place, the couple of them who were up for re-election lost their seats, but it wasn't enough. The school just simply could have said, okay, all right, gosh, clear. We're clear now. They're relying on a Minnesota law firm, from what I understand. And the lawyer in Minnesota is giving them the exact opposite advice of what Wisconsin Institute for Law and Liberty is giving. They're saying the lawyer in Minnesota is telling a Wisconsin school district, nope, you're going to have to make all those girls walk halfway across the school, wait in line to use a single stall bathroom so that one mentally unstable boy can use the facilities at his leisure. That's what apparently one lawyer is telling them, and they choose to listen to that lawyer from Minnesota rather than to other legal advice. They're going with that guy.
Well, we're going to have to litigate this, and we may have to take it up to the U.S. Supreme Court. There's a number of cases at the U.S. Supreme Court that have been coming down on these gender issues. So it started with a year ago with Mahmoud, which is the case about education based on certain books and things that were the right of a parent to direct the upbringing, the educational upbringing of their child. Transgender books in schools that were being sort of crammed down on parents without any notice or opportunity to opt out, and we got that right back in Mahmoud. And then just a few weeks ago, the case of Mirabelli came down, which said that secret gender transitions are unconstitutional. We're going to have the sports ban cases up, which says, West Virginia and Idaho saying that, boys cannot participate in girl sports. Those are likely going to come down on the side of the parents in those cases in the states that want to ban those activities. So this will be the next and maybe the final frontier in this legal issue is about whether a boy can basically hold an entire school hostage to his whims on what bathroom he chooses. And do girls actually have rights under Title IX? And I think that,
right.
Bathrooms is probably hopefully the last thing that the Supreme Court has to decide. And this, this is a unique case. There have been sort of some cases like this, but I think this is the only one pending right now, and maybe the first one in quite a while, which actually was brought on behalf of girls seeking privacy and rights under Title IX. Typically, the bathroom cases are brought by the trans student, and those have been percolating for many years. But this is a unique case, and we think that this one might be worthy to go all the way to the U.S. Supreme Court.
I hope it is. I do hope it is. But so here's the question for you as a lawyer. Let's say, okay, New Richmond says, eesh, we're not a real, deep-pocketed school district here. Dan Lennington is a good lawyer. Corey Brewer is a good lawyer. These guys are talented. We're just going to say, okay, we're going to rescind the policy. Then you guys don't have a case, correct?
Well, we have a case for what's happened in the past, and we would have to resolve that with the school district. So they have up to this point been violating the law, and our client's entitled to damages, and we're entitled to attorney's fees for what's happened so far. It would be a nice step if they rescinded the policy. But there should be some punishment for the school board making this decision, and they can't just get away with it by just changing their policy the minute they get sued, because there's a lot of time and effort that goes into putting these things together.
So it doesn't foreclose the legal actions that Wisconsin Institute for Law and Liberty can continue to pursue. That was my question about this. I want to ask about Title IX. What's the point of Title IX? When it's talking about sex discrimination, but let's talk about the point of Title IX. The intention of Title IX was to protect girls. That's who it was drafted to protect. That's who it was meant to protect. And yes, it protects from sex discrimination, but it was meant to protect girls. It's the reason why we have investments in girls' sports. It's the reason why we have protections for girls and girls' privacy, because we have this law. And so the idea that somehow Title IX didn't automatically just prohibit a school board from discriminating against girls like this blows my mind. And on the sports question, Title IX in and of itself should be sufficient to answer the question of whether or not it's okay for boys to displace girls in sports or hurt girls in sports or ruin girls' opportunities in sports.
Yes, Title IX is about the distinction between boys and girls, men and women. That is the whole point of the law, is that boys and girls, men and women, are different and have different needs. And the idea, about Title IX, so, we have women's lacrosse teams, we have women's soccer teams, we have, women's tennis, we have all these women's sports. Do we have them because they make a ton of money for the universities? No, we don't. We have them because sports teams in the sporting experience provides a particular benefit about leadership and teamwork and life lessons and hard work and paying off that is an educational benefit for the student. And if we just look at sports, like UW football, as like a way to make money, then there's going to be no reason to have girls sports because they don't make any money. But that's the point, is not that these sports make money. It's the point that these are student athletes that are learning valuable lessons about life in the context of their sport. That's why we have sports in schools. That's why we have sports in high school. We have sports in college. It's because it's an educational process to go through sports and to learn things about yourself and your teams and how to work together. And, I think a lot of employers will say, I'd like to hire somebody who actually participated in a high school or college sport, because those people have a different set of values, a different understanding about how life works. And there's a benefit to that. And just to say, like, we're not going to protect girls' sports because they don't make that much money for the endowment or whatever, is that's why Title IX was passed, so that we're going to have equal access to sports, educational offerings, facilities, all sorts of things are going to be equal, because the value of these things is not in the income that they generate. The value is what the kids are getting out of them. And that's why it's important for girls and boys to have separate and equal things. We're allowed to say the separate and equal in gender and sex. We're not allowed to say separate but equal in race, but we are allowed to say it in the sex situation, because men and women are different and have different needs, and we value those differences between men and women. We all embrace those differerences every day between men and women. And why can't the school district of New Richmond value those differences too?
No, it's beyond bizarre. It's truly, because it also protects girls. Title IX also does some other things as well. It also protects girls from sexual abuse, sexual assault, by nature of giving them private spaces as well. So Title IX confers a whole bunch of responsibility on an institution. And New Richmond is essentially saying they are not obliged, at least in this instance, to protect girls in any capacity whatsoever. So again, I think Title IX in itself is sufficient, but you're saying this has to get all the way to the United States Supreme Court, which is dumb. But here we are, everything, because this is what the left does. This is a progressive critical theory in action, where everything gets inverted, turned inside out, so that the meaning of discrimination becomes the opposite of what it actually is intended to mean, and the law becomes the opposite of what it's intended to protect. And so, you're forced in every single instance, no matter what the policy. So we should have already had it asked and answered for these other gender-related, cases that have already gone. Well, the logic applies to sports. The logic applies to bathrooms, right? But we can't do it that way, apparently, because when the progressives get a dog toy in their mouth, they shake it until all the stuffing comes out, and you're forced to actually rip it out of their teeth.
Yeah, and all along the way, we're billing our time. And, at the end of the day, the taxpayers of this school district are going to have to pay my bill. And if they don't like that, they should probably elect different people to their school board. I don't like taxes going up because they have to pay attorney's fees, but that's what's going to happen. If they have to litigate this all the way to the U.S. Supreme Court, it's going to be a very expensive bill for the taxpayers of that district.
Good.
And so there is some punishment here, but, at the end of the day, it's people need to realize they should vote for rational elected officials who make reasonable decisions and follow the law, not people who are imposing some gender ideology and cramming it down the throats of little teenage girls who just want to go to the bathroom and feel safe in private and do what normal girls do in bathrooms, which is different than what boys do in bathrooms. And to recognize there are differences in sex, and that we appreciate and embrace those things. In denying this idea and allowing this sort of gender fluidity and this ridiculous behavior is just denying the existence of humanity, and it's just very offensive. And somebody's going to have to pay.
If you wanted to accommodate that mentally, unstable boy, you could have had him use a single stall bathroom. Simple as that. Obvious. It's the obvious answer to that. Obvious. But of course, it's not the obvious answer when you're talking about critical theory and critical politics. Good to have you on the program. I feel zero sympathy for people in New Richmond who are going to have to pay your bills, Dan. I do. I have none, zero for them. And you guys are good lawyers. So hopefully, you charge what you're worth. Good to have you on the program. Thank you.
Thank you, Vicky.